The Delhi International Arbitration Center welcomes you all to the concluding session of the 3-day eventful Delhi Arbitration Weekend. On behalf of the Delhi International Arbitration Center, I extend a special welcome to our chief guest, Mr. Kiren Rijiju, Honorable Union Minister of Law and Justice, whose gracious presence here today is a testament to the importance of arbitration as an alternate dispute resolution mechanism in India. We also extend our most heartfelt welcome to our guest of honor, Honorable Mr. Justice Sanjay Kaul, Judge Supreme Court of India, who has joined us today to share his insights and thoughts on the future vision of arbitration. Our warmest welcome to all honorable judges of the Supreme Court and High Courts and all other distinguished invitees and dignitaries present. The international arbitration community has witnessed a paradigm shift in its practices as a result of the COVID-19 pandemic. The future will see the permanent adoption of a few of the temporary pandemic-induced measures. With virtual hearings and paperless arbitrations becoming the norm, the arbitration community is likely to see a rise in issues pertaining to cybersecurity, standardization of data, and the use of artificial intelligence. The future will also see the community take more concrete steps towards diversity in arbitrator appointments and greener arbitrations. The session traces the evolution of arbitral practices during the pandemic and discusses the resolve of the international arbitration community to adapt to whatever the future beholds. I request Honorable Mr. Justice Sanjay Kaul to kindly address this gathering. Please, sir.
Check the microphone. Mr. Vibhu Bakru, who has been the creator of all this drama which is necessary. Justice Rekha Palli, chair and speaker of all the invigorating sessions that took place over this weekend, and over which there has been a lot of talk and positive talk on what has been done. Ladies and gentlemen, I am delighted to have been invited by the Delhi International Arbitration Center to deliver the special address for this Delhi Arbitration Weekend. American author Max Lucado once said, "Conflict is inevitable, but combat is optional." Today, parties have a wide range of dispute resolution processes to choose from. In most cases, they are no more confined within the four corners of a courtroom, both infrastructurally and legally. In these cases, they have the autonomy to choose which law will govern them, who will decide their dispute, and which rules will they follow. This has been proven to be particularly useful to resolve transnational disputes. In essence, the basis of these alternative methods of dispute resolution is that the dispute is theirs, and so the autonomy too should be theirs. They are not, in that strict sense, constrained by the fixed legal parameters, where it may be sometimes difficult for them to understand, for the other side to understand what is the crux of the dispute, where the problem lies. ADR mechanisms are a huge achievement as they help in easing heavy dockets of the courts and in the long run in reducing pendency of the cases. More than that also, I feel there are better methodologies for solving the disputes, and not only because they provide the necessary alternative pipelines. This weekend has been a celebration of one such ADR mechanism, i.e. arbitrations. I am glad that the organizers of the event have not only kept relevant and timely topics for discussions spanning over the last few days, but have also kept the closing session to discuss the Arbitration Vision 2030, what the future beholds. This is because the arbitration is a living concept which evolves with time and constantly reflects the need of the parties in dispute. I would like to take India's example to demonstrate how the arbitration landscape evolved with time and taught us lessons for our future developments. Even before this alternative disputes resolution method was recognized statutorily by the Indian Arbitration Act of 1899, the Indian civilization had encouraged settlement of differences through a system of panchayats, where people chose the deciders of their disputes. And I keep saying those panchayats were not really mediation. They were in a sense arbitration, because what was decided was final, not with the choice to walk out of it. People chose, as the 1899 Act was limited to the three presidency towns of Madras, Bombay and Calcutta, arbitration was codified in Section 89 and Schedule 2 of the Code of Civil Procedure, 1908, which extended to different regions of British India, to which the 1899 Act did not extend. Due to the technical nature of these acts, the Arbitration Act 1940 was enacted. However, this Act did not deal with the enforcement of foreign awards and was criticized for being ineffective. In words of Justice D. Desai in his judgment, Guru Nanak Foundation's case, the way in which the proceedings under the Act are conducted and without exception challenged in courts has made lawyers laugh and legal philosophers weep. India's effort to become a pro-enforcement jurisdiction began with two major statutes, that is the Arbitration Protocol and Convention Act of 1937 and the Foreign Award Recognition and Enforcement Act of 61, which shows that India has always wanted to be part of a group of countries that adhere to the protocols and conventions related to the alternative dispute resolution mechanism for speedy resolution of disputes arising from international commercial agreements. Consequently, the Arbitration and Conciliation Act 1996, based on the 1985 United Nations International Commissions for International Trade on said trial model law and rules, was enacted. The Act came in a very fortunate time for India, as India was undergoing major economic reforms and was opening the borders to foreign trade and business. The 1996 Act is an evolving one, as it is constantly updated with amendments such as 2015, 19 and 21. These events in India's arbitration story are bound by a common thread, that is, the vibrancy of the arbitration system and its ability to constantly mold itself with time to become more adaptable. This dynamism has led to many landmark judgments in India, which strengthen the arbitration role in solving domestic and international disputes, especially with India still grappling with the after effects of the COVID-19 pandemic. The year 2001 started with recognizing the doctrine of severability in NN Global Mercantile Private Limited, where the Supreme Court held that the arbitration agreement would not be rendered invalid, unenforceable, or non-existence, even if the substantive contract is not admissible in evidence or cannot be acted upon on account of non-payment of stamp duty. Therefore, the Supreme Court upheld the spirit of the party autonomy in PSA Mid Solutions Private Limited, where it was held that two Indian parties can choose a foreign arbitral seat, and that parties to such foreign seat arbitration will be able to obtain interim relief from the Indian courts. This was a much needed clarification, as the debate on the issue has been going on for a considerable amount of time. Later, the Supreme Court ironed out the issues on emergency arbitrations. The 246th report of the Law Commission of India recommended an amendment to the Arbitration and Conciliation Act that decisions of emergency arbitrators be given statutory recognition in India. This was also reiterated by the B.N.C. Krishna Committee report. However, this recommendation was not accepted, and as such, the phrase emergency arbitration was omitted from the 2015 amendment to the Arbitration Act. Recently, in the Amazon.com case, the Supreme Court held that an award by an emergency arbitrator in an Indian seated arbitration constitutes an order under the Arbitration Act and will be enforceable in India. In Gemini Bay Transcriptions Private Limited, the Supreme Court held that a foreign award would be enforceable against a non-signatory who is acting as an alter ego to the signatory to the arbitration agreement. At this stage, I would like to point out two factors that I believe have greatly lent to India moving towards an arbitration-friendly regime, and we can hope to see many positive changes in these areas. The first, I would begin by saying the institutionalizing the arbitration system in India. The advent of international institutions such as the ICC, the CAIR, the London Council of International Arbitration has provided impetus to the growth of institutional arbitration in India. In fact, this encouraged the growth of several homegrown arbitration institutions, such as the Indian Council of Arbitration, the Delhi International Arbitration Center, the Mumbai Center for International Arbitration. With a growing interest to resolving disputes outside the judicial setting due to their cost effectiveness and efficiency, institutional arbitration is seeing a positive growth across the country. Based on the report of the high-level committee to review the institutionalization of the arbitration mechanism in India, chaired by Shri Krishna, the 2019 amendments took place and seek to improve institutionalization of arbitration in India, such as by providing the Arbitration Council of India. The Arbitration Council of India will carry out various functions to give a boost to the institutional and also remove the many practical difficulties, such as framing policies, to grade arbitral institutions, and accredit arbitrators as per qualification and norms which are included in the 8th schedule, as inserted by the 2019 amendment to evolve policy and guidelines for the establishment. Operation and maintenance of uniform professional standards in respect of all the matters relating to arbitration and ADR mechanism. Holding training, workshops, etc. in areas of arbitration to establish an electronic depository of the arbitral awards made in India and also to promote and encourage the ADR mechanism. If I may say so, the mediation bill, which will hopefully see the act maybe possibly sometime in this year, also is geared towards this institutionalization in another form of an alternative dispute resolution mechanism. Secondly, the strict adherence to the principles of non-interference by courts. Indian courts have shifted towards a pro-enforcement stance with a strict adherence to the principles of non-interference with the arbitral awards, which is the bedrock of the New York Convention. For instance, in Vijay Kataria's case, the Supreme Court opined that there was no appeal is granted against a judgment which recognizes and forces a foreign award. The Supreme Court should be very slow in interfering with such judgments. It should entertain an appeal only with a view to settle law if some new or unique point is raised, which has not been answered by the Supreme Court before, so that the Supreme Court judgment may be used to guide the course of future litigation in this regard. One hopes the future awards debtors will take lessons from Vijay Kataria's case and refrain from adopting similar litigation strategies, which may only be unproductive by the end of being counterproductive. I often say that the parties must learn to accept awards, is how I put it. Unfortunately, the public sectors more so require this, because there is no point in carrying a battle through 2 or 3 tiers of scrutiny just to complete a formality. I think that's something, I'm sure the Law Minister will look into it, how best that's something which can be attended to. These changes have set the stage for future developments in Indian arbitration landscape, and we can hope that India will continue to witness such pro-arbitration stances. I believe that these future developments for arbitration in India are in tandem to those that might take place globally, and we are in an exciting stage domestically and globally with respect to arbitrations. With globalization and liberalization, the world has become more interconnected and transnational commerce has become imperative for the global economy. With these rising interactions as a natural corollary, international disputes have also risen, and the international arbitration community has always responded to demands of these changing times. Even when globalization and commerce were suffering because of COVID-19 pandemic, the international arbitration community shifted from physical to electronic submission and increased the use of virtual or remote hearings. This is a testament to the arbitration effectiveness as a dispute resolution mechanism as many national courts had come to halt due to pandemic restrictions. Although these may have started off as a temporary setup, it is clear that these changes are here to stay, even in the future, unless more cost-effective and efficient alternative is proposed and adopted. Not only did the pandemic act as an accelerator for increased digitization of arbitral proceedings, but also compelled the stakeholders in arbitrations to look for practical ways to mitigate their carbon footprints, forge a more sustainable path by moving forward. Given the impact of climate change in today's highly connected globalized world, all stakeholders in international arbitration will have to evaluate their contributions to the same. The campaign for greener arbitrations, which is an initiative to address the carbon footprints of international arbitration and mediation, has developed a set of green protocols to encourage adoption of more sustainable practices and reduction of carbon emissions. While no one can predict the future with certainty, it is upon us to speculate and analyze what we as community may witness as the future of arbitration on the basis of trends that have taken shape recently for the years leading to the pandemic and beyond. The virtual or hybrid hearings will become the norm, and the physical hearing slowly will be an exception, is my belief. I sometimes wonder about the stark transition in our modus operandi in courts over the last few years. The courtrooms are adorned with black robes, finding their way between piles of files to make effective legal arguments. No doubt it had a charm. But when the pandemic hit, our systems were brought to a halt. To keep the wheels of justice running as smoothly as possible, we introduced the concept of virtual hearing in courts. India became a developing country, faced infrastructural and connectivity issues. But it did not take too long for all stakeholders to find a way of operating efficiently. Instead of running from one court to the other, lawyers are now able to attend hearings of different proceedings while sitting in the same room. I would argue that the virtual system actually increased the efficiency of our system, and hence even today, I operate on a hybrid model where I permit the lawyers to appear on video conferencing, if need be. This is particularly helpful for lawyers or parties who need to travel long distances in short duration of time to attend their matters. This is something the Chief Justice of India also, on a recent occasion, had emphasized that having created this vast infrastructure, it is necessary to utilize it to the best possible. And considering the government has sanctioned a large amount for further use of technology in the judicial working of the judicial system. Similar to my experience, I hear that widespread adoption of virtual hearing formats have now made them a standard and sometimes the preferred feature of arbitration, even after lifting the pandemic restrictions. With business also transitioning into a hybrid work model, virtual hearings seem to be consistent with the evolving business needs of a rapidly evolving world. Perhaps the biggest advantage for a party is an overall cost reduction, as from the lens of efficiency, virtual hearing have done away with the need of unnecessarily expend money and time to travel to various parts of the world for conferences or hearing. It has also made it easier for arbitrators and practitioners to find suitable hearing dates. Some arbitral institutions, such as the ICC, ICDR, etc., have explicitly added virtual hearing in their rules. Parties can now, therefore, accordingly adopt for arbitral relations as providing facilities of remote hearing and may also include specific provisions of remote hearing in their arbitration agreements. I don't consider virtual hearing to be a foolproof system. Our experience has shown us that they come with their own set of problems. One such problem is due process risk, such as holding virtual hearings over the objection of one party, concerns about inadequate access to technology, logical and schedule issues relating to time and different time zones, and the risk of influencing witnesses during their testimony. Such an issue could in turn lead to challenge to arbitral awards, and that should be a careful deciding. Depending on the circumstances, tribunal and parties may organize hearing, with some participants being present in person. and others joining via video conferencing teleconference in a hybrid format. If I may permit, I'll just sit down and read it out. I have not been too well, so it's causing me a little concern. This seems like a mere technical issue at the first, but actually it's an integral point of consideration for an arbitration. As parties to delay an arbitration proceedings may insist on physical or hybrid hearing, I suggest that the arbitral tribunals take specific care to balance the due process, necessity and efficiency in coming to a decision, if the mode of conducting the arbitration will become a contested issue. As a future of arbitration will focus on technology tools and technology-related practices, arbitrators and practitioners will be expected to have basic technology competence, including awareness of attention to cybersecurity and data privacy issues. The use of technology in arbitration is of course not a novel idea per se anymore. Parties today use technology for exchanging communications through online e-planning platforms, storing information for access by stakeholders, prepare a less case presentation and electronic documents, scanning or digital signatures. But in future, not only will there be increase in using these types of technology, but this may also be new and alternative means to exchange information. All stakeholders in arbitration will be required to update with such procedures, and the costs related to such arbitration may also increase consequentially. Artificial intelligence is another area which is likely to be a growing concept. We were all surprised by the invention of search engines like Google, where we could find answers to questions in one click. Now, none with the rise of chat, GPT and innovative AI chatbots that can give people answers directly to just about any query possible in an easy conversational way. The use of artificial intelligence in a legal field has been an ongoing debate. To explore the use of artificial intelligence, the Supreme Court of India has constituted an Artificial Intelligence Committee, which is looking into the various aspects. And the London Council of International Arbitration, as an example, has amended its rules to provide for a composite request covering claims arising from more than one contract. When it comes to arbitrations, AI can be used for selectively suitable experts, counsel and arbitration, as is done by portals like the Arbitral Intelligence and Billybot, with the use of AI reports which are generated by analyzing the data from awards and questionnaire. However, AI tools must be used very carefully as they come with risk associated with due process rights and public policy violations. I believe the arbitration committee will focus its time and effort to creating arbitration workspace with reduced environmental footprints, active reduction in energy consumption and waste, corresponding electronically and avoiding printing, avoiding unnecessary travel, etc. There are few other developments taking place at a fast pace, and the push for such change began even before the pandemic. Two of them are diversity in international arbitration and third-party funding of significant claims in arbitration. The need for diversity in international arbitration is apparent due to increasing diversity of parties, arbitrators, and even the type of disputes that are now being referred to arbitration tribunals. In fact, another byproduct of virtual hearing will be assessing newer and more diverse arbitrators. This may lead to a greater geographical flexibility in appointments, promotion of unrepresented groups such as women by international arbitration community. In my opinion, the global community has started acknowledging the importance of diversity in arbitration. As a result, arbitral institutes like the ICC have been publishing statistics to increase awareness on creating diverse and inclusive panels. Members of the Arbitration Committee have signed pledges like Equal Representation in Arbitration, ERA pledge. However, there's still a long way to go. To maximize diversity, all stakeholders must play their respective roles. While opting for arbitrators, parties need to understand that a diverse arbitral tribunal results in a well-rounded award with all perspectives considered. For this to happen effectively, arbitral institutions can provide model standard clauses, imposing a higher level of responsibility to parties to consider the diverse panel. Arbitral institutions may provide consolidated information on individuals belonging to underrepresented communities to inform parties of potential arbitrators and can also have appropriate international community focus on diversity. This would permit more effective comparisons between arbitral institutions and tracking of progress on diversity across the international arbitral community as a whole. The dialogue and diversity must not end until the goal is met. There must be several conferences, webinars and workshops to increase awareness of diversity and ways to improve the inclusivity in international arbitration. Coming to the aspect of third-party funding, as we know, arbitration proceedings may be subject to exorbitant costs and may involve high-value claims. This is where the notion of third-party funding has seen a dramatic rise in popularity. Jurisdictions like Australia and the United States support third-party funding. And the courts in the United Kingdom are also reconsidering the principle of maintenance and shampati, which prohibited any individual who is not party to the suit from financing the litigation process for any benefit. However, even though it can be said that third-party funding is broadly accepted in the common law jurisdictions, there remains legal uncertainties in some jurisdictions about whether traditional funding structures conflict with the doctrine of shampati and maintenance. Under this doctrine, it is prohibited for third parties with no legitimate interest in the legal dispute to provide funding in litigations and arbitrations in exchange for proceeds from the support case. For example, the Supreme Court of Ireland has held that third-party funding does not, in fact, violate this doctrine. This position was also followed in Singapore and Hong Kong until both jurisdictions enacted their respective legislations to exclude third-party funding from the doctrine of shampati and maintenance for international arbitration. This is because third-party funding poses some questions and issues that remain to be completely settled, including issues pertaining to disclosures, confidentiality, and the doctrine of shampati and maintenance. However, this is an area that may soon be explored by the international arbitration community, especially in the aftermath of the global pandemic, when it is crucial to discuss an aspect of law that has affected thousands of potential claimants' legal financing. Albert Einstein had said, "In the middle of every difficulty lies opportunity." Arbitration as a concept has developed as a strong method to resolve disputes by finding an opportunity to improve itself when there was a difficulty. I believe the international arbitration landscape will continue to develop after the changes we discussed today take place. I thank everyone for the patience and congratulate the Delhi International Arbitration Center for organizing such a spectacular weekend and hope that many such discussions will continue to take place. Thank you and Jai Hind.
Thank you, sir, for sharing your insights on the Arbitration Vision 2030 and what the future beholds. Your address was a true reflection of your passion and expertise on the subject. Your contribution leaves us enriched and has given all of us present here much to think about. I request Mr. Kiren Rijiju, Honorable Union Minister of Law and Justice, to kindly address the august gathering. Please, sir.
Honorable Justice Sanjay, Kishan, Kaul, the Honorable Judges of Supreme Court, Justice Rama Subramaniam, Justice Rishikesh Roy, Justice Vikram Nath, the Chief Justice of Delhi High Court, Justice Satish Chandra Sharma, Chief Justice Meghalaya High Court, Justice Sanjay Banerjee, the Chair of this organizing committee, Justice Rekha Palli, the President of Delhi International Arbitration Center, Justice Vibhu Bakru, all the Honorable Judges of Delhi High Court, Honorable retired and the present judges participating here, all the invited dignitaries from India as well as from various countries participating in this very important event. First of all, let me thank the organizing committee for inviting me on this valedictory function on very, I should say, path-breaking Delhi Arbitration Weekend. And I believe that the 3 days intense sessions which you have must be very eye-opening for everybody, because it is a platform where one can not only share but express views also. Let me thank Justice Sanjay Kishan Kaul for coming and sharing the moment despite not keeping well. I could see and this comfort which he had to endure, but he managed to participate and address the gathering. That shows his commitment towards the arbitration, all India matters which he had referred to during his address, and also his concern for Delhi High Court. I also acknowledge many important personalities who had taken part in this Delhi Arbitration Weekend. Now, I don't know how you have coined the term Arbitration Weekend, but it turned out to be a perfect weekend for Delhi High Court, especially the judges and the lawyers. So when we know that it is a combination of the teams which can make any effort successful. So I must acknowledge both the bench and the bar of Delhi High Court for making this event very memorable and successful. I am told that the Chief Justice D.Y. Chandrachud also addressed in the inaugural session, and also the parallel sessions, technical sessions which had been addressed by various personalities, including the Honorable Supreme Court judges, went very well. This morning I tried to gather some informal informations, some feedbacks that how much this event had created impact in the world of arbitration in India and abroad. And the result which I got was quite positive. In fact, not only the high courts, the subordinate courts in our country, they had keenly watched the entire proceedings of this Delhi International Arbitration Weekend. And since these were live telecast, so even the people from abroad also had access to the proceedings. I have come with a small, very simple note, very quick observations, nothing much to offer because you all know me. I can be contacted, I can be given any kind of task. I'll always be there to ensure that the need for creating a very, very robust system of arbitration in India will have to have the backing of the government and the judiciary and all the stakeholders. And I know that the high quality and the meticulous planning of the event had touched upon so many topics. When I was going through the topics which you had discussed during various sessions, that itself throws so many lights. And I think by far, this is the most extensive event to deal with arbitration in India so far. Let me compliment the entire organizing committee. Currently, the majority of arbitrations in India are conducted as ad hoc arbitration. Now, I tried to find out in the ministry also, when I took over the charge of the Ministry of Law and Justice, I tried to assess why we prefer ad hoc arbitrations in India. What is that we have yet to get into the total mode of institutional arbitrations? There are various attributes which I will not dwell into length today, but there are issues. And we must appreciate each country has its own taste, certain characters, which will require time to sync with the international practices. But having said that, if India has to become a global hub of international arbitrations, then we have to sync with the international practice. Because of the majority of the people prefers this ad hoc arbitration, it becomes susceptible to the court intervention. Justice Kaul also mentioned about it, and I am told most of the people are of the same opinion. On the other hand, the institutional arbitrations are regulated by the rules of an institution that provide for a more structured and secure process. In addition, parties can benefit from the expertise of the arbitral institutions having good quality infrastructure. You all know that India has so many arbitration centers at this moment. If you compare with some of the countries, especially the smaller countries, our size is really big in terms of numbers. Having said that, sometimes quantity is okay, but quality matters more. Now, besides this Delhi International Arbitration Center, we have recently created India International Arbitration Center. In many cities of India, we have different centers. Let me make it very clear. All the centers are complementary to each other. There has to be stiff competitions, but that competition is inherently necessary to make India a global center. We have to ensure that we learn from each other and we cooperate each other. There is no place for any conflict of interest from between one center to another center. So we have to work together. With the emphasis on institutional arbitration, it is essential that new arbitration centers are set up in non-metro cities also, and a wide spectrum of disputes to the extent feasible are encouraged for being resolved through arbitration. The government at its level has been active in bringing in the requisite changes in the policy and the laws to promote institutional arbitration. The whole system of institutional arbitration is crucial in creating and enhancing the ease of doing business environment. It is further important to emphasize about it being linked to ease of living. Ease of living will be witnessed where there is prosperity in the society and a robust system promoting ease of doing business atmosphere. As we all are aware, for the enforcement of contract, as per the World Bank Ease of Doing Business report, India takes as much as 1,445 days to resolve a dispute, and 31% of the claim value for the dispute resolution is spent during the process itself. These are some of the realities which we have to be very mindful. I have personally interacted with honorable judges of the Supreme Court and to large extent the honorable judges of the High Courts. Without the support of judiciary, the efforts to promote ease of doing business and ease of living will remain a distant dream. The judiciary has also been receptive of the various measures which have been taken to strengthen the dispute resolution measures in the country and appreciates the concerns of the government to meet the objectives in this regard. Our objective is very clear. I am very happy to acknowledge that Indian judiciary has on many occasions come forward and displayed their cooperation to ensure that alternative dispute resolution mechanisms in India are successful and arbitration ecosystem becomes robust. In this direction, the courts in India have been proactive in constantly adopting arbitration-friendly approach. Justice Kaul just mentioned a while ago, the Supreme Court of India paved the way for enforcement of emergency arbitral awards in India, seated arbitrations in the Amazon Future Group case. Similarly, the Government of India has taken various steps and measures towards in field of arbitration and made every effort to keep the law on arbitration, that is, Arbitration and Conciliation Act 1996, in sync with the international development. In this regard, you are well aware, Arbitration and Conciliation Act of 1996 has been amended in the years 2015, 2019 and 2021 to meet the need and requirement of the times. As I mentioned a while ago, government has established Indian International Arbitration Center as an independent institution to provide world-class infrastructure and facilities for conducting domestic and international arbitration. This IIAC will also work for setting up of arbitration academy to train arbitrators in India who would be at par with the expected global standards. It will also promote studies in the field of alternative dispute resolution and related matters and to suggest reforms in the process of settlement of disputes. It will also cooperate with other bodies, institutions and organizations, nationally or internationally, in the area of ADR. Another important setup which we have taken forward this step is setting up of Arbitration Council of India. It has been provided for pursuant to insertion of Part 1A in the Arbitration and Conciliation Act 1996 by way of Amendment Act of 2019. Arbitration Council of India is expected to incentivize arbitral institutions to improve their functioning and to bring uniformity of norms and standards among the various arbitration institutions by framing policies governing the grading of arbitral institutions and holding training, workshops and courses in the area of arbitration. Now we all talk about making India international hub of arbitration. Now how will it happen? I tried to have a glance of other known and renowned international arbitration centers like Singapore, Hong Kong or Paris or London or New York. If you see the total numbers of cases, it is nothing compared to what we have the Delhi International Arbitration Center. the figures differ so much. I will not go into the details of the figures, but if one has to compare the mere numbers of cases referred, Delhi International Arbitration Center established in the year 2009, as per reports, has nearly 6,373 cases listed and 4,993 hearings being held in the year 2022. Considering the vastness of our country, besides the ongoing domestic and international commercial arbitration, even if a fraction of the total litigation in the country is resolved through arbitration, the potential for setting up of arbitration institutions like DIAC and IIAC is quite huge. These unexplored and hidden potential, in my view, is the key for developing India as a hub and center of arbitration. I strongly feel this is India's moment. It has to happen. India cannot be denied. When the whole world is looking at India, when India has emerged as the fastest growing large economies of the world, already a 10th largest economy size in the world, how can India be stopped? We just have to seize this opportunity. And this event is a perfect direction towards that. I feel it is essential to briefly recall the success story of Singapore. When I was deliberating a discussion in the parliament, most of the members of the parliament were saying, why India cannot become like Singapore? Why India is not becoming like London or Paris or New York or Hong Kong? And I tried to assess myself, what are the attributes? The English speaking, the hosting place for so many multinational companies, the English common law, everything is there. But what stops? Is India not a global center? Today, anybody can reach Delhi from any part of the world. Bombay can be, reached within a few hours from any part of the world. I don't think anybody finds India a distant place in terms of geographical locations or distance. Then what is that? Then if Singapore can become a global hub, why India cannot? That is why I firmly stated with conviction that nothing can stop India. If anything can stop India, it is we Indians. We only can stop ourselves. Nobody else can stop us. It is our moment. We must seize it. Now, the necessary requirements for establishing arbitration centers of international repute are already available in India. We have the advantage of time zone also. India, if you look at the global map, if you just open up the Atlas map or any projection map, look at the location of India. The location itself is so attractive. I don't think any country today in the world can deny that. Now, with this English being a common language of all the Supreme Courts in India, I don't think there is anything which can stop us from making ourselves and becoming a global center. The high-level committee on arbitration constituted by the Government of India under the chairmanship of Justice B.N. Krishna in 2017 had recommended that there is an earnest need for creation of a dedicated arbitration bar in the country, and which comprises of young persons also. In my view, there arises also a consequential change in the legal studies curriculum at law colleges and universities to promote specialized study of ADR mechanisms for law students so that the requisite exposure of the field is available to them when they enter the profession. Technology, we all know, I don't need to spend much time on it. We have a very clear-cut target and objective before us. Indian courts must go paperless. If the recent budget is of any indication, it reflects the intention of the government. The 7,000 crore which we have devoted for the phase 3 of the e-court projects itself shows that the requirement of the judiciary, the intention of the Indian judiciary and the government are in sync with each other. I have requested personally the Chief Justice of India, D.Y. Chandrachud, that as he headed the e-committee for a long time, as a Chief Justice of India, he should continue to head it for some time, because we are on a mission mode and we need to complete and accomplish the task. He has already taken lots of steps along with the Chief Justice of the High Courts, all the e-committees of different High Courts. We are very happy and excited also that during this COVID pandemic, India has emerged as a global leader. Not only I'm talking in terms of volumes, but in true quality of the works, to look at the achievement which Indian courts have managed in this pandemic time. During phase 1 and phase 2, I saw there were some lacking, some shortcomings, but phase 3 will be super fast. And the budgetary allocation is as per the requirement of the E-Committee of the Supreme Court's proposal. And my officers in the Department of Justice have worked very closely with the Supreme Court E-Committee, and we will continue to work together very, very closely. The oral dispute resolution provides a convenient and cost-effective way of resolving disputes, and also can be used for small claims cases. Use of artificial intelligence is so crucial in today's time. AI can be used to assist arbitrators in tasks such as document review and analysis, legal research, and drafting of awards. AI tools can also be used to identify patterns and trends in the data, which can help in making informed decisions. Government is fully committed to enhancing digital capabilities and take institutional arbitration to the next pedestal to enhance the overall competence and proficiency of all the stakeholders involved in the arbitration process. Government aims to assist in establishing an arbitration ecosystem which has the quality arbitrators and is easily accessible to increase confidence and conviction of the parties in arbitration as a credible alternative to litigation in courts. Further, aim is to promote and encourage arbitration for smaller contractual disputes other than large commercial disputes, including where one of the parties is a micro, small, or medium enterprise. With the adequate support of the Government of India relative to the policy and legislative interventions, the dynamic field of arbitration is an avenue for the lawyers to take up and contribute, which in turn can augment the resources and quality of arbitration in the country, establishing India as a hub of arbitration. Robust, conversant, and well-informed arbitration bar would further promote recourse to arbitration as a viable alternative dispute resolution mechanism. Our vision 2030 is to see arbitration space remain dynamic, amenable to quick adoption of best practices, and conscious of the needs of the time-bound and final adjudication of contractual disputes. The coming together of various stakeholders in the field of arbitration over the last 3 days would have provided an opportunity for brainstorming and exchange of ideas. It is hoped that learnings from this extremely well-organized symposium can lead to further improvement of the arbitration ecosystem and adoption of global best practices in our country. When we talk about area, Justice Kaul mentioned, we are expecting to bring the mediation bill. I was in fact targeting last year itself. But after we tabled the bill in the parliament, every member of the parliament desired that it should be referred to the parliamentary standing committee. So when the bill was sent to the parliamentary standing committee, I can very well divulge here, there's a huge difference between what government proposed and what parliamentary standing committee came up with numerous recommendations. While preparing the mediation bill, we have consulted large numbers of stakeholders, including very senior retired Supreme Court judges, High Court judges, and some sitting judges also. Look at the difference in perception also at times. When I thought the bill being tabled in the parliament was perfect piece of legislation, there come a huge variations in the recommendations. And I realized that when I went through the recommendations of the Parliamentary Standing Committee, some of them were so relevant. So we created the recommendations into three categories. One, the recommendations of the Parliamentary Standing Committee which we can accept, and we have in fact informally accepted. I cannot comment right now officially because it has to go to the cabinet. Second, which we cannot accept. Third, it can be accepted with partial modifications. So the field is so wide open, and I'm sure when we finally come out with that amended piece of draft legislation, it will do a wonder in the field of ADR. Now, without going much into the other issues, let me assure that when the courts initiate certain actions, the support from the government is definitely expected, and I assure that. We have to work together. And I feel so privileged to be part of an event which is court-driven. But Delhi High Court has taken such a wonderful initiative. It is incumbent upon me as the Minister for Law and Justice to be part of the process. It is my duty to ensure that whatever comes out, all the recommendations of this 3 days intensive deliberation, government has to support it, because it is not just coming out of blue with these suggestions, but after so much of research, deliberations and understandings of the issues on the ground, you have come up with these suggestions. I'm sure at the end of the day, Rekha Palli, Bibu Bakri, both of you will share these documents with me as soon as possible. And our senior judges of Delhi High Court, Justice Sharma, Justice Mridul, Justice Mohan, they are all experienced judges. And I'm proud of Delhi High Court for taking such a wonderful initiative. The whole, not only India, as I said, the whole global world of arbitration is looking at India because of this initiative. These last 3 days, we have become citizen of all the eyes. I'm extremely proud to be part of this great event. Congratulations to all the organizers and all the stakeholders, and I must acknowledge the participations from the foreign countries. This kind of support from our friends and people from the field, from all important countries take part. This will definitely become very important factors for making India a global hub of international arbitrations. And finally, I thank all the Honorable Supreme Court judges, all the judges from the different high courts, the Chief Justice, Sanjay Banerjee. I was very excited. He has come from Northeast, so he represented me here. And of course, the Delhi High Courts Delhi High Court judges are all here, but other judges have also joined. That is a very encouraging sign. And with the guidance of the senior judges from the Supreme Court, I see no reason to worry that there are huge obstacles before us. Everything is a highway for us, and we have to embark on the journey to make India truly a global hub of international arbitrations. Thank you very much.
for your encouraging words, your enlightening address, and making this event memorable with your presence. I now request Honorable Justice Rekha Palli, Judge High Court of Delhi, and member Delhi International Arbitration Center to kindly deliver the vote of thanks.
A very good afternoon to all. The last 3 days have been really a very, very special time for all of us. And now I have the most pleasant task of expressing my gratitude on behalf of the Delhi International Arbitration Center, Delhi High Court, to express on the successful culmination of the first ever edition of the Delhi Arbitration Weekend, or DAW as we have come to call it. I must say the event has witnessed participation from over 450 delegates from 14 nationalities who deliberated over key issues on arbitration over the last 3 days. I think this was unprecedented in the field of arbitration, not only in Delhi, but no part of the country has ever seen such huge participation. As Justice Kaul, who had to just leave, just said, elements of arbitration could be seen in the age-old Panchayati Raj system in India. But over the years, while arbitration has become the most preferred dispute resolution mechanism, what has happened is that with the increasing popularity of arbitration, especially in international and commercial spheres, the challenges and issues have cropped up. Now, the answers to these challenges lie in deliberations, learning from each other, and sharing of best practices. And that is what the whole event was meant for. The event was envisaged with this and the brainstorming which we saw in the last 3 days. I'm sure it will go in a long way in connecting the Indian chapter of arbitration with the larger international saga. That was the aim. As the Honorable Law Minister has said, that was the aim of this conference. The journey would not have been possible without the contribution, support and effort of so many people who have worked tirelessly to make this event a huge success. As a part of the organizing committee for DAW, it is my great privilege to express my sincerest gratitude on behalf of the High Court of Delhi to Honorable Dr. Justice D.Y. Chandrachud, Chief Justice of India, who very graciously presided over the inaugural session of the program. Justice Chandrachud, as we all know, has spearheaded numerous such initiatives, right from using technology as a powerful tool in the field legal system for availing ADR mechanism to address high pendency of cases. In its address at the inaugural session, the Honorable Chief Justice emphasized on the importance of virtual hearings and gender diversity in arbitration, once again showing his commitment for making the justice delivery system more inclusive, transparent and accessible. I sincerely thank him for gracing the occasion. I also express my heartfelt gratitude toward Mr. Kiren Rijiju, Honorable Union Minister of Law and Justice, for taking out time out of his busy schedule and for gracing the concluding session of DAW. His address has been really encouraging. The manner in which he has spoken about the High Court, our High Court especially, and the arbitration system and this conference is really something thought-provoking and will give us food for future deliberations. I must mention that the Honorable Minister has always backed the need for institutional arbitration in the country and has therefore taken a very keen interest in the event right from the very inception. Even though when we thought of this program or the event, I had envisaged we will have to persuade him to join us and grace the occasion, but I will share with you, he was more than, I did not have to do that. I will take it that this was probably because of his respect and love for our High Court, and also because he wants to promote institutional arbitration. And today, Mr. Kiren Rijiju has really inspired us by assuring us that he will stand by our High Court in every such endeavor. Thank you so much, sir, for all your support. DAW is culminated today with reflections over what lies for the future of arbitration, and also I would like to thank Honorable Justice Sanjay Kishan Kaul, Judge Supreme Court of India, for sharing his enlightening thoughts, words and vision with us on these issues of immense significance. In fact, Justice Kaul, if I may say, is like an alumni of the Delhi High Court and has truly stood by the Delhi High Court as a real rock for all these years. I think this you have all seen today. Even though he was feeling so unwell, but he still did not break his promise to come here, and that I really thank him from the bottom of my heart for joining us, even in this state where he had to rush because of his ill health. In addition to being a long history of learning and discourse on ideas, India is special in many other ways. For us Indians, gratitude is not a mere emotion. It's a way of life. In fact, if you would have all noticed, even when we greet each other with namaskar, we fold our hands and bow our head in gratitude. That is the way we Indians behave. For us, gratitude is a real way of life. In line with this, and on behalf of everyone who's present here, I would sincerely thank Lord Peter Henry Goldsmith, who traveled halfway across the globe to enrich us with his vast experience. I would like to especially thank him for his stimulating address in the inaugural session. His suggestions on the steps that India could take to establish itself as a reliable destination for international commercial dispute resolution would definitely help India to develop as the hub of institutional arbitration in the coming days. We are truly indebted to him for having made the time to join us. I earnestly thank Honorable Mr. Justice Satish Chandra Sharma, Chief Justice High Court of Delhi. He was exceedingly encouraging towards the idea of this conference right from the very word go. Chief, I express our heartfelt gratitude to you for always being so supportive of our efforts and attending almost all the sessions with so much enthusiasm. I also take this opportunity to thank Honorable Mr. Justice Rijiju Bhartu, Chairperson Arbitration Committee, for being our motivational force. He, I would say, is truly the architect of this event. He has nurtured this conference, as also the Delhi International Arbitration Center, with his sheer dedication and sincerity towards achieving the goal of excellence in institutional arbitration. I would also take the opportunity to express my utmost gratitude towards Honorable Justice Subramanian Prasad, a co-member of the organizing committee for DAW with me. He has been a source of constant strength and has worked tirelessly over the last few months over only cups of tea and bun samosa from our canteen, nothing else he got, to put every little nicety of the conference in place. I must also mention the crucial roles of Honorable Ms. Justice Pratibha M. Singh and Honorable Justice Naveen Chawla, fellow members of the Arbitration Committee, who were extremely forthcoming with their ideas and suggestions and were readily available for all deliberations related to the conference. I also take this opportunity to thank Honorable Mr. Justice Sachin Datta, who has joined the Arbitration Committee only very recently, but came up with some very innovative ideas to make the event more vibrant. I also thank all my senior colleagues, including Justice Mridul, Justice Manmohan, Justice Shaddar, for giving their weekend to us in this endeavor to promote India as the hub for international arbitration. I thank all my other colleagues who have joined, Justice Nimi Pushkarla, Justice Manmeet, Justice Rao, Justice Banerjee, and Justice Amit Mahajan, and all others who probably could have done other things on a weekend but thought this was something which they needed to attend. I am really, really thankful to all of you. I would also like to now express my appreciation towards Mr. Seshankar, a co-member of the organizing committee of DAW, who along with his very proficient team has worked hard to bring this event to life. It is because of his efforts that DAW has seen the participation of delegates from so many nationalities, of which today we are very proud of. Thank you, Kishan, for helping us in ensuring that both the DIAC and India find their rightful place in the world map of international arbitration. A renowned poet, Sir Herbert Reed, once said, and I quote, "I can imagine no society which does not embody some method of arbitration." This thought and the growing importance of arbitration in legal systems across the world has repeatedly been echoed over the last 3 years. Eminent speakers from diverse backgrounds, ranging from judges of Hon'ble Supreme Court, judges from different high courts across the country, to practitioners and experts, have all exchanged valuable insights over matters of growing interest in arbitration, like such as party autonomy, corruption and arbitration, role of judiciary in appointment of arbitrators, emergency arbitration, and the third-party funding, amongst others. These deliberations and detailed discussions between the panelists over the last 3 days have indeed been thought-provoking and have definitely enriched one and all. I must share with you all that the preparation for these deliberations, which we witnessed in the last 3 days, started weeks ago with all the panelists, including the Honorable Judges of the Supreme Court and the High Court, interacting with each other over numerous Zoom calls. I must really thank them for taking out this time for us and making the effort to make the discussions meaningful. I take this opportunity to thank all the chairs, speakers and participants who attended the 18 working sessions of DAW after the inaugural session set the tone for the event. I sincerely thank all the Honorable Judges of the Supreme Court, right from Justice Sanjeev Khanna, Justice Gawai, Justice Suryakanth, Justice Ravindra Bhatt, Justice Ramasubramaniam, who is there, Justice Roy, who is also there with us, I'm happy to note, Justice O, Justice Vikram Nath, Justice Hima Kohli and Justice Narasimha for sparing time to share their thoughts with us. I also thank all the Honorable Judges from the Bombay High Court, Calcutta High Court, Madras High Court, Kerala, Meghalaya and Orissa High Courts who took out time from their extremely busy schedules to enlighten us with their views. In fact, I must also mention that some of these technical sessions were powered by key institutional operators in the field of arbitration in India. I also express gratitude towards all these institutions for their role in supporting this event. I also take the opportunity to acknowledge the efforts of the advisors for this program, Senior Advocates Mr. K.V. Vishwanathan, Mr. Darayas Khambata, and Mr. Gaurav Banerjee, all the members of the Executive Committee and the young members of the Working Committee whom you could see running around here and there, helping you with everything. And the session coordinators and the team of event compeers led by Dr. Aditi Chaudhary, Director, Delhi Judicial Academy, who selflessly volunteered for and worked on various aspects of this program. I would also now like to especially acknowledge the tireless efforts put in by the dedicated team of the officers of the Delhi Higher Judicial Services and all other staff members working at the Delhi International Arbitration Center. The team led by Mr. Nikhil Chopra, coordinator of the center, and Dr. Sumet Kumar Sethi have toiled for months together to ensure that all the arrangements for the event were in place. I wholeheartedly thank them for their efforts. I must mention that it is only because of their effort that the center remained fully functional even during the conference. We did not give any adjournment. That was something unthought of when you are having a conference of this scale. I would be failing in my duty if I don't acknowledge the effort of every individual who has helped in putting this conference in place. But I know I will stand between you and the lunch, so I will not be in a position to name each one of them. But the slide being projected in front of you shows the sheer number of people who have come together to make this event a huge success. My sincerest thanks to each one of them and apologies for not being able to take their names personally. Most importantly, I cannot emphasize enough the role of the bar in making this program a huge success. From organizers to participants, from guests to volunteers, the bar permeates every aspect of this program. Thank you all for participating so enthusiastically over the last 3 days. I particularly thank Mr. Mohit Mathur, President, Mr. Jatan Singh, Vice President, and Mr. Sandeep Sharma, Secretary, and other office bearers of the Delhi High Court Bar Association for all their cooperation. Mr. Mathur is there, I can see him. Mr. Mathur, I must thank you for encouraging us and giving all your support. We had to close the few chambers for 2-3 days. He even agreed with that. Last but not the least, I thank Mr. Ravinder Dudeja, Registrar General, and other officers of the Registry of the High Court of Delhi, officers of the PWD and other agencies for making arrangements for this conference. I thank Terrace Telecommunications for having volunteered to offer their revolutionary services throughout the conference. These transcripts, I assure you, will be used in the next issue of the Centre's annual journal, and I will tell the Honourable Minister, we will use these transcripts. Whatever we are speaking is being transcribed there on the screen for you all to see. So we will have these transcripts very soon, and we will definitely compile them and send it to you, sir. I also express gratitude towards all other dignitaries and members of the media and everyone who's present today. Thank you for joining us on this weekend. I sincerely hope that you all had a memorable weekend, and DAW has set the ball rolling for continuing conversations and many such dialogues in the future. Thank you and Jai Hind.
Thank you, ma'am. I will now request Honorable Mr. Justice Satish Chandra Sharma, Chief Justice, High Court of Delhi, to kindly felicitate our chief guest, Mr. Kiren Rijiju. Thank you, sir. Thank you, sir. We shall conclude the session with the playing of the national anthem. I request all to kindly rise for the national anthem.
शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 जय
We conclude this session. I request all to kindly join